Good afternoon, everyone. I'd like to begin by acknowledging the traditional custodian of the land on which we meet today and pay my respect to their elder, past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples. Then I pay my special respect to all the fallen heroes from Spring Revolution in Myanmar. I also thank AMI President Dr. Margaret Brand, and all our participants from different parts of the world to join the AMI seminar today. Now, our AMI President, Christopher Lam, will open the meeting. Chris, the floor is yours.
Thank you, May Chair, and welcome to everybody. We now have 28 people present, including Marcus, our lead speaker, and he is from IDEA, but he will explain that as he starts, for those who are not familiar with the organization. But it's very well known around the world for its work on free and fair elections and the democracy process, but that extends to the rule of law and the things we're going to talk about tonight. So thank you very much, everybody, for being here. And when our other speaker is here, we will bring him in. But he's a person who we have to consider anonymous because he's in a situation which is not comfortable for him politically or in his own personal security sense. But I can assure you that he's very well qualified to talk on the topics. So, Marcus, would you like to start now? And you have about 12 to 15 minutes, and we'll see what happens with the other speaker.
Thank you, Chris.
All right. Well, thank you very much. And I would like to begin by saying that I consider this a particular honor to speak to you here on this subject, because there are many others who are academically and otherwise much more accomplished and have published much more about these questions and these issues. So I consider myself in a lucky opportunity to have your attention and to share a few of my own reflections and thoughts about this subject, the rule of law in Myanmar, which has been occupying me for more than the past decade in different ways. I'll speak briefly about a few areas that are of particular interest, but this is a subject that one could talk about at least a week if to sort out all the different aspects and angles. I would also like to start by saying a few words about international IDEA and about myself. So for the past 3 years now, I have been leading the Myanmar program of international IDEA, which is the Institute for Democracy and Electoral Assistance based in Stockholm. It is an intergovernmental organization with 34 member states, including Australia, that was set up in 1995 to be pretty much the only intergovernmental organization entirely dedicated to promoting democracy worldwide. So we have a mandate to provide assistance to both member states and non-member states. Myanmar is, of course, not a member state, but we were invited in about 2013 to work with various governmental counterparts in the effort to strengthen democracy and electoral capacity. And we had done that with the help of various donor partner countries to build up what eventually became the biggest country office of international IDEA in the region. So when I began in 2020, we were about 40 people in the country. But after the coup, we had to essentially pull out physically from the country. So I am at the moment in Bangkok, but I am often in other parts of Thailand, and I'm generally based in Stockholm. And I have not been back and will not go back to Myanmar under the current circumstances. And we do not have any single staff member or colleague working in Myanmar at the moment for obvious reasons. But we do continue to work in Myanmar and reach people all over the country pretty much on a daily basis, online, obviously. But we also do an increasing number of in-person events, in particular in Thailand, but also other countries. And that also includes Australia, where we are happy to partner with various academic institutions. So this is sort of the rough setting of where I'm coming from. I personally have been working on Myanmar starting in late 2011, early 2012, when I helped UNDP and then later also USAID and other organizations in developing democratic governance programming, which included also what we called rule of law assessments, justice sector assessments, and developing programming aimed at strengthening the rule of law. And we can, of course, unpack what that means in this concrete circumstance and how successful this may have been. With my current involvement in Myanmar is through a program that is framed as Building Federal Democracy in Myanmar. It is the successor program to a program that was called My Constitution, which some of you might have been familiar with. And it is basically entirely focused on working with all those striving to rebuild Myanmar as a democratic federal society. We work closely with the elected MPs, with the interim institutions, the National Unity Government, and the various member organizations of the National Unity Consultative Council, and also with academic institutions and society at large, very much with the focus of not only achieving the process of rewriting a new constitution for the country, including also subnational state-level constitutions, but also strengthening or let's say increasing the chances of actually implementing these changes and creating the foundations for transforming the country into a society where the rule of law is more than just lip service and is actually something that is felt by citizens regardless of their identity, and where the rule of law prevails, so to say. But I'll get to that a bit later if I have time. The one aspect that I would like to focus on here for the discussion's sake is related to my own background as a constitutional law student from Vienna, Austria, where I did my basic law degree, and where my thinking was very much shaped by the Austrian, German, Central European thinking about rule of law, which we call Rechtsstaat or Rechtsstaatlichkeit. So I come from that continental European tradition of thought, so to say, and that to some extent still also frames my thinking about law and legal issues when I work in other countries. And so when I look at the situation in Myanmar from, let's say, taking the rule of law angle, then that is very closely related for me with the question of constitutionalism. Constitutionalism is very closely related to the rule of law. It's not exactly the same thing, but I would say you cannot have constitutionalism without the rule of law. And in my opinion, it is also very difficult to have the rule of law without constitutionalism. Constitutionalism would mean that you have a set of legal norms, the Constitution, that stands above all other legislation in a hierarchical order, and that is self-executing in the sense that you would have independent judicial institutions such as a constitutional court that can help enforce the terms and the text and the meaning of the Constitution, even vis-a-vis the legislature. So even a parliament would be bound by the limits of a constitution in a context of constitutionalism, which is, of course, not the case if you consider the parliament to be supreme and the bearer of sovereignty on its own, which, of course, as you know from the British tradition, is still sort of a prevailing thought around the Westminster model of democracy, but it is not necessarily something that is widely considered sort of practical in many parts of the world. So I think also that in Myanmar we have a situation where we strive towards not a situation of parliamentary supremacy, but a situation of constitutionalism where all state authorities are bound by the principles and the terms and the normative parameters of a constitution. Now, the interesting question is, of course, whether the 2008 constitution that was considered the legal framework for the past decade can be considered such a constitution that provided the basis for constitutionalism. And there we very quickly get into questions of legitimacy, both in terms of how the 2008 constitution was put in place in the first place, and to what extent it may have acquired legitimacy in practical terms later on, even though one can raise very important questions about how it originally came about. I would say that when the 2008 constitution was originally imposed by the military, very much also against the protests of groups like the NLD and many, even the United Nations had serious doubts at the time, and many international observers. But it did become essentially the unquestioned legal framework for those parts of the country that were under the control of the military. And that, of course, as we know, was not all of the country. And there are still also actors, stakeholders that have different narratives about legitimacy, and that would say that the 2008 constitution was never a legitimate legal framework for the country. This is, up for debate, but I think what is important is that when we fast forward to the 1st of February 2021, we see a military that, in the sort of false assumption that the 2008 constitution gave it ultimate power to take over the reins at will, goes and tries to activate the state of emergency provisions of the 2008 constitution, but realizes that there is an obstacle, which is that some of the steps required to declare such a state of emergency are not under the military's control. And that is in particular the role of the president declaring such a state of emergency, and having to agree to such a course of action, which, as we know, was not the case. And so we have actually put out at the time a very detailed analysis of what we call the unconstitutionality of the coup, essentially making the coup a coup. Because it is, of course, interesting that the military still maintains implausibly and of course, without much credibility, that it is still acting on the basis of the 2008 constitution, which is why it considers an election as the only way out of this dilemma that it has put itself into. We also know that the term limits for the extension of the state of emergency have already several times been exceeded, but the military now argues on the basis of necessity, the good old constitutional magic formula that justifies anything and everything, to extend this state of emergency, but it still keeps up the illusion, in a way, that the 2008 constitution is still in place. I'm saying illusion because, in my opinion, and on the basis of our analysis, we consider the 2008 Constitution at this point no longer applicable and no longer legitimate. And that is not exactly the same as saying that the CRPH, the parliamentary representatives, have abrogated it. The interim institutions sometimes claim that they have actively ended the validity and the applicability of the 2008 Constitution. But I think it is, more of an academic question, a very interesting one, nevertheless. But in any case, what matters is the end result of this consideration, which is that the 2008 Constitution is no longer the legal and constitutional framework to which the country will return to once this current interregnum is over. Instead, the interim institutions have gone ahead to not only declare the 2008 Constitution invalid and inapplicable, but have started a new process of rebuilding the country under a new constitutional framework, the Federal Democracy Charter, which is not an interim constitution in its own right, but it includes a roadmap towards a new constitution. And I can talk a bit more in detail about the various steps in this process. Essentially, the current situation is considered to be an interim period during which only a transitional constitution can be prepared for what would be a transitional period after a handover of power of some sort to legitimate institutions. And it is during that transitional period that a constituent assembly would convene and write a new constitutional framework for what will be a federal setup for a new country, essentially. And at the moment, we are still at the rather early stages of this process. There is the Federal Democracy Charter gives the mandate to adopt a transitional constitution to the National Unity Consultative Council, or rather the People's Assembly, but it has been stuck for various reasons, and only the National Unity Government has done some preparatory work on the basis of previous constitutional texts in order to get the process started. So at this moment, I would say Myanmar finds itself in a constitutional vacuum, in the sense that there is no uncontested single constitutional framework governing state authority in the whole country. One should also say that the areas controlled by the military are very tenuous. So it is geographically less than half of the territory where the military can exercise authority. But even there, it is not doing so in the sense of normal state legitimacy, but only through the application of brutal force and violence and intimidation. And that can hardly be considered the basis for government legitimacy, as is sort of generally considered necessary for sort of both for state recognition, but also actually for the idea of constitutionalism. And in this regard, I would like to also point to the very interesting texts written by Joseph Ross on the authority and interpretation of constitutions, which I have found to be very useful guidance for trying to understand better the different dimensions of moral legitimacy of constitutions, both looking back at the previous 2008 Constitution, but also in terms of the current contestation around sort of the rule of law. And what is clear from Joseph Ross's writing is that a constitution must be a stable, written, superior law, but one that is also justiciable, where legal acts can also be declared inapplicable by independent judicial bodies and institutions. But more than, in addition to these formal legal requirements, it is of course important that there is an acceptance by the bulk of the population of the legitimate exercise of political power on the basis of such a constitution, which we do not find at the moment in the military-controlled areas. What is really interesting is that is the question whether in the non-military controlled areas, what is emerging there. And there is a different set of situations, basically, where some of the areas are and have been controlled and governed by what used to be known as ethnic armed organizations or ethnic revolutionary organizations, and they differ very much from each other. But there are certainly proto-government functions exercised by such organizations in certain areas, and they some of them have also been trying to introduce elements of democracy, but also access to justice and rule of law. But to what extent that fully meets the aspirations of, for example, the Federal Democracy Charter in terms of checks and balances and independent judiciary, that remains to be seen. There are also areas under the more direct control of the National Unity Government, in particular areas in Sagaing region, Magwe, where the PDFs have, the People's Defense Forces have been able to gain sort of de facto control over a number of quite large territories, actually, where increasingly the question has arisen of who exercises judicial power, not just in terms of dispute resolutions between citizens, but also with regard to the exercise of public power. And so there is, for example, I mean, there are reports, for instance, on detentions that could be considered arbitrary detentions. Some would even say political prisoners that are held in some of these liberated areas by the revolutionary forces, by the democracy actors who are actually fighting against military dictatorship and are claiming to do so on the basis of the Federal Democracy Charter, but who have until now not really fully been able to establish what one could consider normal democratic state functions that also include independent access to justice, to independent institutions, oversight mechanisms, and accountability mechanisms. And this is really, so this is now the last thing I want to say, is that this is where the more academic discussion on the validity of constitutions and the continuity of norms in this revolutionary situation meets the reality on the ground and in a way poses a challenge to all of us who are trying to help the people of Myanmar and their institutions to rebuild democracy and the rule of law. And that is how concretely can we do that in order to assist these emerging state actors to, in a way, get it right from the start. And it is very, very difficult under these revolutionary circumstances to rebuild the state-citizenship relations in a way that can be considered as based on the rule of law, because not only is there a great uncertainty in terms of which norms and which rules are actually applicable, but also there is a great capacity issue among these emerging institutions in order to administer not just effectively, but also lawfully and with accountability. And in this regard, we have been trying to work with the various parts of the national unity institutions, in particular the Ministry of Justice, Ministry of Human Rights and others, Ministry of Federal Union Affairs, but also now increasingly try to work with the subnational actors, in particular the state level councils and some of the ethnic armed actors, in order to, first of all, assess the situation as it currently presents itself, and try to develop models that can be applicable and practical for the current circumstances. And here, I believe that there is a particular role also to play for legal education institutions, in particular universities. As you know, the state of legal education in Myanmar was rather below international standards, I think one can say, to put it mildly, in recent years. But there has now been an effort to kickstart legal education as part of the democratic revolution. And there are at least 2 universities, the Spring University that has a law faculty, and also the Irrawaddy Law School that has started up with basically teachers and students who joined the civil disobedience movement and have been trying to not just provide emergency legal education, but also engage in some reform and modernization of legal education, with a specific focus also on immediately addressing the current rule of law related needs of the interim institutions on the ground. And I believe that these efforts are very much worth support. And I know that there are several Australian universities and partners supporting these initiatives, and I hope that that will also continue. And this is sort of from a practical side, what we also try to do with various webinars, seminars, publications, trainings, and outreach, trying to advance and promote these ideas of legality, of constitutionality, of access to justice, of the rule of law, because I want to take it at face value that this is what this revolution is actually about. When I talk to the various stakeholders and actors among these in this democratic coalition, then they convince me that they really want to build a new country that is based on human rights, on equality, on non-discrimination, and a federal country. And all of that requires a really reaching a different level in terms of rule of law and also constitutionalism, that in turn require a lot of support and capacity building. And so with this, I just want to throw this out here for discussion. There is a lot more one could say about the various things I mentioned, but in order to have a discussion, I think it's better I stop talking here now, and I look forward to your feedback and comments.
Thank you very much, Marcus.
Thank you,
And
Marcus.
there is a lot for us to think about in what you've had to say. Thank you very much. And there will be quite a number of questions, I'm sure. I don't think that our other speaker has been able to reach us. And I know that he's in Yangon and that he's subject to the normal deficiencies of the internet system in the country. And he feared that this might happen, but we'll see what comes. He might be able to join us yet. But in the meantime, we have plenty to work on and work with, and plenty of questions. One of the questions that came to us came from a person who's with us who wants to know what consideration is being given to restructuring the country's political economy.
Sorry to interrupt, Chris.
Yeah?
Yeah. Our commentator is lecture 4.
Oh, lecture 4. Is that you?
Yes.
Oh, good. I didn't know what name you were choosing to be when being anonymous. So please, I invite you to speak. And as I said, he's in very difficult internet conditions at the moment, as well as needing to remain anonymous. But he's very well known and a very good speaker. Please speak, Mr. Lecturer.
Okay. Can I?
No, you've gone mute.
Can you hear me now?
Yes, yes.
Okay, thank you. I will briefly comment on what Marcus said. The two phrases, they are almost, to be slightly not cynical, motherhood and apple pie statements, phrases, rule of law and constitutionalism. The fact is that in the past 60 years or so, about 80% of the time, in the meaningful sense of the word, the rule of law and constitutionalism is missing. I would like to demur or challenge, not from what Marcus said at all, but from the Western model of saying that whether a regime, a government, or a country follows the rule of law is whether it follows the Constitution. That would be applicable, say, in a more or less semi-democratic constitution like the 1947 Burmese constitution, like the, for example, Indian constitution of 1947, the Malaysian constitution, etc. But for Burma, 62 to 74, there was no constitution. And the 74, going back to the past, 74 constitution was, and for want of a better word, if not an oppressive document, it is an enabling document for the regime. It is not an enabling document for the people to get rights or duties, meaningful duties even, but it is to enable the regime to do whatever, almost whatever they want. The one-party system stated in the 74 Constitution, it is an oppressive document, not an enabling document. And by following the 1974 Constitution, if you take the rule of law, one of the criteria of the rule of law, it doesn't match. They will say one-party constitution is written in the Constitution, so we are following the Constitution, so one party is okay. So nobody dare challenge it, at least internally, when the regime was in power. Now it takes 23 years before the 2008 Constitution came into force. And of course, Marcus rightly pointed out that even they do not quite follow the 2008 Constitution. Sometimes the order or decrees made by the regime, current regime, says according to so-and-so section, so-and-so subsection of the Constitution, I issue this order. But within days of the 2021 takeover, going back 59 years, almost to the month of Ne Win terminating the services of the Chief Justice, abolishing the Supreme and High Courts of Burma, effective noon on 31 March 1962, the regime also terminated all the services of the NLD appointees. Not that they are brilliant or innovative judges as such, if I may say so, compared to the pre-1970 or 1965 judges, even NLD appointees, in terms of quality, in terms of boldness and independence. Now, the Constitutional Tribunal also, that is not done according to the Constitution, and they don't even, from what I recall, you can look back at the English translation or the Burmese original, they don't cite the provisions of the 2008 Constitution when they sack the judges and they appoint new judges, because the Pidutluto or Pidongzutluto must be called and it must be approved. When they are sacked, why they are sacked, they must be impeached first. This process was not followed. So they don't make the pretense of following the 2008 Constitution. 8 out of 9 constitutional members of the Constitutional Tribunal were also terminated. Only Cho Sam, the man who spoke in 2013. I think Marcus attended that seminar on February 10, 2013. I won't go through that. And only he is left. So there is no one would dare challenge, like in Pakistan. In Pakistan in 1972 and 1958, the legality of the Ayub Khan regime was challenged in 1958. Then Supreme Court says that no, it is revolutionary legality. They cited Kelsen. That was the state versus Dosso. Luckily, it is written in English, so I can read it. In 1973, 20th April 1973, the then Pakistani Supreme Court rejected Kelsen and say Kelsen theory of effectiveness of revolutionary legality. And they ruled that the previous Yahya Khan, not Ayub Khan, Yahya Khan regime detention order against Miss Jalini, I think, or her relative, Jalini versus the state of Punjab, is illegal. So we had no such thing post 1962 in Burma. Pakistan had, Malaysia has, India had. We are not comparing with Western countries. We are comparing with neighboring countries who had British colonial heritage. Dr. Mau Mau, the late Dr. Mau Mau, in his doctoral thesis at Utrecht, University of Utrecht, titled Burma in the Family of Nations, not in all books. In some books, if it says in English, in rule Stellingen, I think it's a Dutch word, Stellingen. Stellingen says that the British brought the rule of law into Burma and it is good. That was Mau Mau's statement of 27 June 1956. He dated it. So we have deteriorated too much. Okay, now going back to the opposition, to be frank, I'm also cynical. I've been burned my fingers, so to speak, many times. I've been disappointed when the opposition shared power. So I am also skeptical of what the opposition is doing. And what if, to me, currently in the almost I said, unenvisageable scenario of sharing power, that's the very, very, very best they can do. Because I'm a pessimist. Sorry. My previous experience made me a pessimist. I am skeptical about that. So to comment, I thank Marcus for all the efforts and for all the support that give to the opposition group. I am sorry to say that I am not that enthusiastic about the future, even in the best case scenario. Pre-February 1, 2021, I only had 70% chance of a coup. I was wrong, it was 100%. So I am not encouraged by current developments. I thank Marcus and all others and those who are training and helping to do what they can under the circumstances, but I am not that optimistic regarding future developments. I'm sorry to say, and in a pessimistic, some would say cynical comment, but I thank those who are listening and those for inviting me to speak and for Marcus for making the presentation. Thank you.
Thank you, Sia.
Yes, thank you very much. That's really interesting, and it gives us even more to talk about now. I'll return to where I was before. It was a question that came in, which is about the way the country is going to handle the political economy. But let me expand it a little bit for both of you, both of our speakers. It's the question of what happens in the future, really, to the federal state of the country. Looking at what the Constitution does now and what it's effectively done since independence in different ways, how do you see a federal state being set up under a constitution, and how will they get lawyers who are going to be able to do the necessary things to protect that federal state from the depredations of governments, national governments. Marcus, do you want to comment on that first, please?
Yes, well, first of all, thank you very much to the commentator, and thank you also for many years of enlightening conversations and reading your texts. I very much agree with what you say, and I also would say I may share your sentiment in terms of optimism or pessimism, but in a way, I sometimes describe it like I find myself standing next to a burning house of my friends, and I am not in the position of leaning back and saying how likely it is that anybody will make it out alive or not, but I'm rolling up my sleeves and try and save what I can and help the family in planning ahead for rebuilding that house, as difficult as it may be. I think, I don't think that the, let's say, best case scenario is the most likely one at this point. But even if it has a minor chance, then that is the chance that I want to be helping. And that's in a way what drives me and my colleagues and my team to do what we're doing. But I'm not saying that I'm enthusiastic, and it was in a way similar to the approach that me and other internationals had 10 years ago, when we in a way tried to give the benefit of the doubt to that situation that had been created by the 2008 constitution. There was, of course, a lot of glaringly wrong things about the 2008 constitution, but I still think it was worth using that window of opportunity and work to the extent possible with what it did allow, because I think in the end it brought us a bit forward and created sort of some new opportunities. I very much agree with this, with pointing out this issue of fake constitutionalism that is so prevalent, not just in Asia, but really also, this is a worldwide phenomenon where, in a way, the rule of law and constitutionalism has been perverted by the enemies of democracy and accountability. And many autocratic regimes around the world are the first to claim that they are actually acting on the basis of the rule of law. So I think for outsiders and academics, it's really very important to try and find the ways to distinguish the real thing from its fake mirror image, and to be very exact in describing what the rule of law really is and what it requires. And in that context, by the way, I have always been appalled by the misuse and misinterpretation of Hans Kelsen and his teachings. Hans Kelsen was a Viennese law professor who is not only the author of the Austrian Constitution, but also basically invented the model of the continental European Constitutional Court. And his writings on legal positivism have often been abused by autocrats and dictators around the world who do not understand what Kelsen really said and wrote. And so I, in a way, have to take this opportunity to defend Professor Kelsen and his writing, and encourage everybody to look at it again if you think that that's where he was coming from. So in terms of federalism, I think that's a very, very interesting and open question to which I don't really have a very good answer. There are currently different views and different narratives among even the democratic opposition groups in terms of how federalism is to be built in the future. And just to make it simple, I distinguish between two main groups here. One is a group that says that the country is starting from a clean slate, sort of tabula rasa situation, where Myanmar doesn't exist as an entity and has to be rebuilt from bottom up as and when its new federal units decide to do so. The Federal Democracy Charter, to some extent, expresses this view when it says that sovereignty is originally placed with the constituent member states of the Union and the people living in them. But it does so, first of all, without naming these constituent units, and therefore leaving the question open on who are the constituent units that are building this new federation. And it also, at the same time, creates and institutes these national unity institutions as the bearers of this collective sovereignty, and invests the NUCC and the NUG with certain powers over the Union. So on the one hand, you sort of have, and you can say that these are sort of, this is the confederalist view of those who say, well, Myanmar was never really formally, legitimately created in the first place, and we still have to talk about coming together as a union. And then there are the, you can say, pragmatic federalists in a way, who accept federalism as an end result, but have more let's say, the view that there is a certain continuity of identity with Myanmar as it is recognized in international relations and as it holds the seats at the United Nations, and that there is, even when you accept that the 2008 constitution is no longer applicable, that there is a certain continuity with the previous legal order, such as the identity of the 14 states and regions, and their elected or partially elected representative bodies, and other norms and legal legislation as may still be applicable, and the idea there being more that these two views of how this federation is to be built also affects the current efforts of preparing a transitional constitution, because in the NUCC, you have, in a way, both groups represented, let's say, the confederalists and the pragmatic federalists, and they cannot really fully come to an agreement on what is to come first, the state-level constitutions or a union transitional constitution within which and under which the new federalism will sort of be formed. And, you know, I always need to make clear that this is something that really needs to be sorted out by the people of Myanmar and their representatives, and not by international helpers, friends, observers, assistance providers. I always make it clear that when I work on constitutional issues, that we as an intergovernmental organization need to respect the sovereignty of the process of the people, you know, forming a union, and that this is not something where internationals are well advised to interfere directly. And what guides me here very much is that I consider it very important that this is not just an academic discussion, but also one discussion that takes into consideration of what is the best for the people in the current circumstances, in terms of what allows the emerging governance institutions to provide services to people, to provide basic security to people, and how to minimize the overall disruption and risk for additional conflict that may arise from such processes. Okay. And so, this is in a way where I'm coming from.
Yeah, thank you for that. We've got to be quicker, I'm afraid, because we're running badly out of time. We've only got 10 minutes left for our program. Anonymous, would you like to comment on this situation? And when you do so, could you say what you think is the situation under the law of bodies like the WA entity that's now operating with pretty much total autonomy?
I do not know much about what entity the question to translate, so I'll pass it to those who are more knowledgeable on that. Yes, of course, I do not mean to respond to the optimism, pessimism thing. It is my personal view. I'm not saying that we should sit down in lazy despair and do nothing. That is not my point. But so far the efforts has not exactly borne fruit compared to, because I taught in Malaysia and even in the South Pacific. When I compare to those rule of law and federalism situation, even in what is called a semi-authoritarian until recently, or even now, countries like Malaysia, we have had a long way to catch up in terms of both the rule of law and constitutionalism, the quality of the judges, the quality of legal education, which Marcus has mentioned. There is a few hundred at most among hundreds and thousands of law graduates, which has produced in the past 50 years or so. So that is my point in that regard. Since I want to give other people to chance, I would stop here. And I'm sorry that I cannot answer concretely the WA situation. Those who are more knowledgeable can please feel free to comment.
Okay, thank you. But returning now to one of the things that you said in your commentary about judges and their appointment and the way they were appointed under the Constitution and the role of the Bidang Zututor, the Chief Justice Htun, who was appointed after all by the Thein Sein government, he left the court a week or so ago. As I understand the way the law works, he can't be replaced unless the Bidang Zututor endorses a replacement, and there is no replacement for Htun at the moment, which means that the court is without a Chief Justice.
Well, not only Htun, but also other additional judges, including, I think, 2 women judges, females were appointed to the High Court, to the quote-unquote Supreme Court. So I don't know whether you can, but I don't mean to critique Kelsen all the way, but definitely the Pakistani Supreme Court did, whether the critique Kelsen or whether interpretation of Kelsen, I am not sure in their ruling. So basically, I would not fully agree with what Chris says, that there is no Chief Justice and there is no Supreme Court, because the majority of the members are. There is, in factual fact, there is in that regard. Kelsen and effectiveness, so to speak, or even Machiavelli. Rather, Machiavelli and Mao would be more applicable than Joseph Ras or even Kelsen, politically speaking, in that regard. So there is a court, and unless you want to challenge, and where will you challenge? Will you challenge in the Constitutional Tribunal the appointment of the new Chief Justice and the SAC appointed judges? Where will you challenge? So the status quo remains supreme, or remains effective, I would say. Thanks.
Yeah, that's fair. Certainly there is a court and there are other judges which are still there. It's just there's nobody occupying the office of Chief Justice at the moment. That's all I meant by that. But looking to the way the courts actually function, a lot of the work of the courts now in terms of their management of the population, if I can use a gentle term, that's conducted by military courts.
Yes.
Or courts that meet in secret and nobody knows what the arguments are. Often we don't even know what the charges were that they're convicted of. And so the rapper who's been sentenced to 20 years for criticizing the electricity supply situation in Yangon, 20 years. But there's no trial process that anybody can see. There's nothing that comes from that. And in terms of the rule of law, one of the things that the Myanmar system inherited from the British and has maintained, more or less, has been one which sees precedent as part of the way the law's rule is applied to the country. None of that's available at the moment.
Thank you.
Simply
Yes.
a bunch of arbitrary decisions taken by unknown people on the basis of unknown charges. Have you got a comment on that, Mr. Anonymous?
Yeah, indeed. Thank you, Chris. I will request others to comment also because of the time factor. Thank you.
Marcus?
Well, the way I look at it is that all of these institutions and bodies that were set up by the military after the military coup do not have any legal legitimacy and are just appearances of institutions, but that are firmly under the control of military autocratic rule. And this is also what has been confirmed to me by some individuals in these institutions who essentially either refused to take these orders and therefore left, or just complied by necessity of survival and basic needs. There are many people in the embassies around the world, in the leftover ministries that are not supporting military rule, but that basically just comply on a very basic level, but that do not consider the military to be the legitimately exercising power. And I think the when trial defense lawyers are trying to get the best out of various court procedures for their clients, that does not necessarily mean that they recognize this so-called court system under the military as legitimate. So I think it is also to me not conceivable that this existing this sort of coup regime military justice system will be taken over into the new system that the democratic forces are trying to build. So a new justice system, a new court system that needs to rebuild credibility and legitimacy needs to be built. And I see lots of challenges with that, of course, but and there is lots of interesting parallels from other countries around the world where you have seen the regime change of some sort. But to me, it's not obvious at all that the existing so-called court structure, I mean, it was already questionable before the coup to what extent they were actually an independent judiciary, but certainly after the coup, this has this veil of legality has completely disappeared, I think.
Thank you. It's interesting. And what you're saying also takes me back to a comment that was posted in the chat room by our friend Tintanu, who was always one of our most active participants at these seminars. It's about the people basically being forced to accept whatever the military put to them for a vote, including, as she says, 1974. But in fact, I remember better what happened at the time when the public were called upon to support the 2008 Constitution in the referendum held that year. Nobody believed the result. I think that my memory tells me that the official result was that 94.7% of the population voted to support the 2008 Constitution. And that then becomes the fountain of what we now call legitimacy when comparing it with what the military does now. None of it adds up very well. And the NUG is apparently working on what a new legal charter for the country might look like. But how that would eventually be applied to the country or brought before the people and then consecrated as a constitution is very unclear. So we don't really have an easy answer to any of that, but we can go back to what Anthony Ciminello said in the comments about optimism. So we have hope, motivation, the ability to overthrow injustice, and that's very inspiring to think of, but how it's actually going to translate in the longer term is hard to see.
Mm.
But what I hope we would do tonight is to begin a process of considering what the new structure of the country will look like, both in terms of the Constitution and in terms of the way the people accept the way government operates for them. So we will see as time goes along. Is there anybody else who's got a last question before we finish for this hour? I think not.
If I may just comment briefly on what you just last said, I think this is this very interesting question of how do new constitutions actually gain legitimacy? And if you look around the world, rarely do new constitutions derive from previous constitutions in a revolutionary setting, but then they don't automatically gain legitimacy either. So one thing to look at is how the 2008 Constitution was originally imposed, and there you have obviously very big questions on legitimacy and very big doubts. But if you see that over the years, starting in 2012, when in the by-elections, the NLD was allowed to take up seats, and then in the elections of 2015, 2020, when more than 27 million people came out to vote for institutions under this very semi-democratic in the constitution, I think one can say that there was a certain gain of legitimacy over time. But that was a conditional legitimacy with the understanding that the military would stand back and keep to its role that it had given itself in that constitution. When it overstepped that line again, that legitimacy that may have been built up over the years was lost in an instance and cannot be regained, in my opinion. And now the big question is, what would be the process of rebuilding a legitimate constitutional framework that is actually accepted as law by most of the people in the country? Not everybody will be asked for their personal consent, but it has to overall meet the requirements of legitimacy. And that is why both process and substance are very important here.
Thank you. I agree with that very much. And that also raises a point that was made by David Kamru when he referred to the Rakhine state. It's perfectly possible that if there were a fully democratic process with the people understanding what they were doing, that you would find great differences between the different states as to their approval of whatever the new constitution document looks like. Then you could ask questions about legitimacy in individual states, one of which might be, as David suggests, Rakhine. So we will return to all these issues. We have people in different parts of the world who are associated with AMI who will be able to come to us with comment on those kinds of issues a little later. But for now, we'll finish now. And I've let you know that the next of our seminars will be at the end of September, the last Monday, at which the speaker will be the Minister for Health and Education, Dr. Zorwe So. And we are looking at how that might be conducted, whether it will be only on Zoom or perhaps a hybrid like the one we had the other day. But it would be very good to have him speaking. And what I hope we'll be able to do is to get, I know he's the ministers of both health and education, and they're both very important. A lot of his work in Australia is going to be on the health portfolio, but I'd like to see if we can get some focus on the education portfolio here. So thank you, everybody, very much indeed. Thank you, May Chair, for your organizational work. And thank you very much, Mr. Anonymous, for being able to get to us in this difficult